open up into a more substantive response from both the Minister and Deputy O'Callaghan. Deputy O'Brien, would you be in favour of that? Deputy Daly and Deputy Farrell, can we take you together? And that would allow each of the presenters a more substantive opportunity. So if you would note the critical points that Deputy O'Brien has made, and then each of Deputies Daly and Farrell, and respond collectively and to each other as you deem appropriate at that point. Deputy Daly.
Okay, thanks very much, Chair. And again, we're all kind of new to this, and it is a different scenario for everyone. I don't want to repeat points that we've made before, but we had tabled a number of amendments to Deputy O'Callaghan's bill. Actually, we had amended our own amendments before we got to the committee when events developed after that, and we've maybe done now for today a sort of a detailed critique of the Minister's heads, but I think that's probably too detailed for where we're at now. So what we'll try and do is maybe give an initial reaction to some of the broader points. I'll probably forget loads, but we could maybe do some of the more detailed things later. I suppose, first out in terms of the membership of the Commission, specifically the lay majority and the lay chairperson, this is something that we wanted ourselves at the time of Deputy O'Callaghan's bill. So in that sense, we are happy to see that element of it in the government's bill. And I think it's important to say that this isn't about, one in the eye for the judiciary or the legal profession or anything like that. It's really about a particular view that people have of what the judiciary is. And I think for people with a legal background, very understandably, they see the appointment of judges in some ways as a career progression, as something that would be controlled by experts. That's very understandable. But for ordinary people, I think people see the appointment of judges primarily as a social matter. They see judges as working for society, not for the legal profession, and in that sense it makes sense for judges to be appointed by the society that they are there to serve and to be alive to its needs as well. So it is a difference of view, and I think the balance is achieved by equal representation on the Appointment Commission. I think that is the best way forward, giving both sides their due, if you like. And it's unusual to have an even mix of lay legal judiciary on an appointment commission, but it is interesting to point out that when Scotland reviewed their procedure before bringing it into primary legislation, one of the points that they made was that it was a particular strength of their system to have that even mix, and I think that is important. One of the problems I would have is with the idea of the presence of the Attorney-General. Don't see any point in that at all. The Attorney-General is a political appointee, and at least in the early life of the Commission, 2 of the judicial members are going to have been appointed under a political patronage system, while not in any way casting any aspersions on their integrity or their fitness for office. Nonetheless, they came into their positions in that way. I don't see what the purpose of the Attorney-General on the Commission might be, what insights or skills he or she might have, and I think an additional judge perhaps or judicial member would be a better contribution than the Attorney-General. I think there are points to be made about the legal members being nominated respectively by the Bar Council and the Law Society, and we would certainly have questions about that. Obviously, it's no secret that issues have arisen regarding senior members of the Law Society. There's many subjects of litigation and High Court proceedings going on regarding same. Similarly, questions around procedures with the Bar Council have been raised, for example, around their nominee to the Legal Service Regulatory Authority and so on. So I suppose the point we'd be making is that the bill is that judges should be appointed on merit, and therefore the idea of merit should extend absolutely to the appointment of lay members of the Commission. We would agree with that. But why wouldn't it also extend to the appointment of the legal members? That it shouldn't be just because you're sort of in with the in crowd in the Law Society or the Bar Council, or it's whoever's fella's chance is to come up, or his turn or her turn to get don't really like that. That leaves us, we would prefer to see some sort of method where maybe there would be some open public competition, maybe with some minimum qualifications like years of practice or so on, possibly run through the PAS, or as for the lay members, or maybe the idea, as has been suggested by some people, that, for example, the Bar Council's nominee would be elected by the entire bar. And as in the recent selection, interestingly enough, for the practising barrister panel of King's Inn, and a similar process could be engaged in by the Law Society as well. I think we would be of the view that there would need to be clarification in the legislation that the lay membership should, in our opinion, exclude anybody who has practised as a solicitor or a barrister, either over a period of time, by maybe 2 to 5 years or something, or forever, something worth looking at. But, you know, I do think that the expertise of lay people, and that being quantified somewhat, is necessary. I note in the Minister's heads we have a List A and a List B of criteria of expertise. Our read would be that List A is fine, but List B would appear to us to be very restrictive. It would seem to limit the types of people who would be able to come forward. We think it would be important for a wide range of professions or disciplines to be allowed to be considered for the Commission, but with List B, you're kind of looking at the only people who could nearly qualify it be sort of senior civil servants or solicitors and barristers, you know, so we most definitely need to expand that one. I know the explanatory memorandum highlighted notes about the types of lay expertise, but we'd be keen to add to the list the A list, people who have a background, for example, in sentencing and penal reform, maybe addiction, working with drugs, that type of experience, I think, would be important. I think in terms of, you know, Deputy Callum made some good points about how the lay people may bring their political views to the table, pro-life, anti-abortion, pro-choice, whatever, or, you know, light on this. That's equally the case with anybody in society. A legal person could similarly want to be involved in the Commission for precisely the own reason, for their similar reasons. So I do think we need to sort of test the expertise of all. So the merit, we're talking about merit here, so that merit has to apply first and foremost to all people who come to the Commission itself. Now, I think we had proposed an amendment to Deputy O'Callaghan's bill last time in the making of the appointments to the Commission and the Government in terms of meeting the gender balance and so on. Now, I think this is a difficult one because, particularly in the initial stages, we have to recognise that there are huge gender imbalances in the legal and judicial profession already. So kind of forcing a 50-50 split now wouldn't actually give you the best expertise that's there, because the gender imbalance is a reality. So we need to strike a balance between trying to achieve a gender balance, which will probably only in some ways come in time, rather than insisting it as an absolute. And how we formulate that, I think, will be important. And again, diversity clause, those points have been made. It should apply to the legal and judicial members as well. I don't want to spend a huge amount of time, but like in terms of, say, Head 10, for example, the codes of practice function, we think this is very novel. We hadn't suggested it, and Deputy O'Callaghan hadn't either. The basic idea being that the Commission will create a code of practice based on their own research, and that the code of practice will be used, among other things, to draw up a list of selection criteria that the Commission will have regard to in the appointment of judges. Now, we do think that there's some very good ideas in this, but we'd have some concerns about it at the moment in terms of how it's phrased in the heads. For example, why a subcommittee of the Commission is necessary to carry out the Code of Practice function rather than everybody on the Commission being doing it. It's kind of worth pointing out as well that it won't be possible to constitute a committee of 7 members in proportion to the membership of the Commission, given the way the numbers break down. It's not mathematically possible for you to have people, so you won't get that balance based on what it's done now. And I think while given the Commission an important role in monitoring and implementing international best practice on the appointment of judges, informing the selection process is no bad thing. There could be a certain long fingering in this in it, you know. I'd probably tend to agree more with Deputy O'Callaghan in terms of the points around Head 22. His section 15, by contrast, we will be leaning more in favour of Deputy O'Callaghan's section 15 rather than the Minister's Head 22, which is about the list of requirements in relation to the appointment of judges. The Minister's list is extremely thin, and I do think Deputy O'Callaghan's is much meatier and far better in that regard. And you know, we will be tending to err in that direction without repeating any points. Again, I would say on Head 32, I think Deputy O'Callaghan's section 23 on senior appointments is better. As well, it's more sensible than the Minister's suggestion. That's in relation to the appointment of the Chief Justice, President of the Court of Appeal and President of the High Court. His bill is empowering the Commission to make a recommendation to Government for such senior appointments based on merit, at similar principle to all other judicial appointments and so on. And again, I suppose, like Deputy O'Brien, we need more on the constitutional issues. Like, I actually agree with Deputy O'Callaghan with the ranking. I think they should be ranked. It will be up to the government to pick one. But you know, for appointing a commission that's given its view on who the best person for the job is, well, they should rank them. That if they had the choice, ultimately, who would they pick? So I think ranking is good, and I think I suppose, power being vested in the government, because we're being told that constitutionally that's required, that the government can't be constrained in the manner in which it's suggested throughout. I'd have a few questions about some of that as well. I'd certainly like to hear more on that. We do have a number of detailed points on the various heads, but I think they're probably too detailed for the purpose of now. I don't know, they probably touch off the broad points that we would refer to in this regard. I do think we're open to, and I agree with what Deputy O'Brien was saying in terms of the lay people, whether they should be nominating groups with a role for the PAS in it, or some middle ground in that regard. I think there's a role there certainly for getting agreement. But the overall balance and lay chair, we're very happy to see that there, and we think that things can be progressed as well. One thing I would ask them is, and the Minister referred to it, is the Judicial Council.